Restrictions on builder requiring certain lenders. Issue: the builder's contract requires that the buyer use either mortgage company A or mortgage company B. Mortgage company A is also owned by the builder, but mortgage company B is an independent mortgage company. Can the builder require the use of either mortgage company A or mortgage company B? Answer: if the mortgage company A is owned by the builder, there is an affiliated business arrangement. Inasmuch as there is an affiliated business arrangement, the builder cannot require the buyer to use mortgage company A. See 12 U.S.C. paragraph 2607 of RESPA. Although there is a prohibition in RESPA against a builder requiring a specific title company, see 12 U.S.C. paragraph 2608 of RESPA, there is no prohibition in RESPA against a builder requiring a specific mortgage company that is not affiliated with the builder. Therefore, the builder is probably entitled to require a buyer to use mortgage company B. A builder can't require you to use any specific lender, nor can they charge you more for the home you are buying for not using their preferred lender. They can, however, make it appealing to you to use their lender by offering incentives. The builder wants to be in control of the loan and know where it is going. They do not want to lose the sale if they do not know if the lender is a good one. Seller violates RESPA by dictating title company for a transaction issue. Is it a violation of the Real Estate Settlement Procedures Act, RESPA, for the seller in a real estate transaction to specify the title company which will close the transaction? Answer: see discussion. Discussion. Section 9 of RESPA provides, no seller of a property that will be purchased with the assistance of a federally related mortgage loan shall require directly or indirectly, as a condition to selling the property, that title insurance covering the property be purchased by the buyer from any particular title company. See 12 U.S.C. paragraph 2608. The Department of Housing and Urban Development should enforced RESPA before the Consumer Financial Protection Bureau, and had indicated that it would not enforce Section 9 of RESPA against a seller who selects the title insurance company if the seller is paying for the owner's title insurance policy and does not require the buyer to use the title insurance company for the simultaneously issued lender's policy. HUD would take action under Section 9, however, in situations where a seller required a buyer to pay the seller an amount towards closing costs and the seller used a portion of the buyer's paid closing costs for the owner's title insurance without providing the buyer with a choice of that title company. Using realty in a team name is likely unacceptable to the Arizona Department of Real Estate. ADRE. Facts. Several licensees in an office want to create a team and market their services as such. The team would like to include the word realty in their team name, e.g., the Home Realty Team. Issue: can the team use the word realty in their team name? Answer: see discussion. Discussion. The ADRE is clear that team names must not create the impression that the team is an independent entity or separate from the employing broker. AAC R428502C provides, a salesperson or broker shall ensure that all advertising contains accurate claims and representations and fully states factual material relating to the information advertised. A salesperson or broker shall not misrepresent the facts or create misleading impressions. Thus, the use of the words associates or realty should be avoided because they create the impression of a brokerage rather than a team and are typically not acceptable to the ADRE. Broker liable for agent's negligence in causing fire, issue. During an open house, the agent had aromatic candles burning. After the open house was over, the agent removed all of the candles except one. This one candle caused a fire, which resulted in $25,000 worth of damage to the seller's home. The seller's insurance company has reimbursed the seller for the $25,000 in damages and is now seeking payment of this $25,000 in damages from the agent and the agent's broker. Are the agent and the agent's broker liable for the $25,000 in damages? Answer: probably. After paying the $25,000 to the seller, the insurance company has a subrogation claim against anyone who negligently caused the fire. If the agent negligently caused the fire, the insurance company is entitled to the $25,000 in damages from the agent. The agent's broker is also liable under the principle of respondeat superior for the negligent acts of the agent in the course of business. Therefore, if the agent is unable to pay some or all of the $25,000 in damages, the broker is required to make payment. Inasmuch as the broker is liable only as a principal for the agent's negligence, the broker is entitled to indemnification from the agent if the broker has to make any payment. Agents may not accept cash from home warranty representatives for referrals. Facts. After the close of escrow, the home warranty representative offered the buyer's agent $50 in cash for referring the buyer to the home warranty company. The home warranty representative also indicated that he would pay $50 for each subsequent referral provided by the agent. Issue. May the agent accept the $50 from the home warranty company representative? Answer. No. Discussion. The agent accepting the $50 referral fee amounts to a kickback for the referral of business to the home warranty company. This activity is a violation of the Real Estate Settlement Procedures Act, RESPA. The agent, therefore, cannot accept the money from the home warranty representative without violating RESPA. Sue Note, Arizona Realtors. Forms are for member use. Only facts. An Arizona Realtor, R, intends to provide blank copies of several Arizona Realtors, R, standard real estate forms to a friend seeking to sell their own home without the assistance of licensed Arizona real estate professionals. Because the Realtor, R, printed the forms from her ZipForm R account, the Realtor's R name and the name of her brokerage appear on the bottom of each form. Issue. Before providing the blank forms to her friend, the Realtor R asked whether she should remove her contact information from the footer of the forms. Answer. See discussion. Discussion. The first thing the Realtor R should know is that by providing blank copies of Arizona Realtor R forms to her non-licensed friend, the Realtor R is violating federal copyright law. This is the case regardless of whether her name appears on the bottom of the forms. Arizona Realtors, R, standard real estate forms are federally registered with the United States Copyright Office and protected under federal copyright laws. As a result, Arizona Realtors, R, holds the copyright and exclusive right to all Arizona Realtor, R, branded forms. Arizona Realtors, R, grants members an individual license to use Arizona Realtor, R, forms in connection with their real estate transactions. However, members are strictly prohibited from reproducing or distributing blank forms without Arizona Realtors' permission. HOA can collect delinquent HOA fees after foreclosure issue. At the time of the foreclosure sale, the homeowner owes $3,000 in monthly HOA fees. The homeowner has now moved, and the mortgage lender now owns the home. Can the HOA collect the delinquent $3,000 in monthly HOA fees from either the mortgage lender or the homeowner? Answer. The mortgage lender, as the new owner of the home after the foreclosure sale, only has liability for monthly HOA fees after the date of the foreclosure sale. The HOA, however, can file a collection lawsuit against the homeowner and get a judgment for $3,000 plus court costs and interest. After the HOA gets the judgment, the HOA can garnish the wages of the homeowner, attach the bank accounts of the homeowner, and conduct other collection proceedings. Finally, the recording by the HOA of the judgment against the homeowner will be a lien against any real property owned by the homeowner in the county of the recording.